Great. Thanks for coming, everybody. My name is Mark Spivak, and Brittany Atkinson is with us also. We are partners in the Morristown, New Jersey office of Chartwell, doing workers' compensation. We wanted to talk to you today about the COVID-19 presumption statute that just came out. And when COVID hit, I think we all realized that there was going to be a lot involving the law, a lot of questions in different fields of law. One of the things that Chartwell did from the very beginning was we put together a COVID-19 response team. So if you have an opportunity, you might want to visit the Chartwell Law website. It is chartwelllaw.com, 3 L's. There's a lot of information on there from all of the different states. So we handle New Jersey, obviously, but if you have questions about any of the other states that we do business in, it will direct you to various articles and various people in each state that can handle COVID-specific questions. So in particular, in regard to workers' compensation, there was a question in the beginning about whether the workers' compensation statute would change and how COVID would affect claims that happen with people at work. As COVID began to develop, New Jersey was one of the hardest hit states very early on. Our numbers were off the charts. We were hit before most of the other states. So we were sort of on the front lines of developing how our response was going to be to COVID. States slowly began to pass presumption laws in which people who developed COVID at work were presumed to have work-related conditions. And New Jersey initially started looking at this around April or May of this year, and ultimately nothing happened with it at first. It went to the governor, and the governor signed the law in September. So today we wanted to talk about what the COVID presumption law is, what it really means to you as employers and carriers, and what the real long-term impact of this is going to be. We're also going to talk in particular about how to defend against COVID claims and what you can do to sort of limit the liability. So when the law came out, we were looking at a couple of things. Is it going to be a broad-based law that's going to be a long-term situation? Is it just going to apply to this COVID outbreak? What was the presumption going to be, and how is this all going to work? So now that the law is out, we really want to focus on how this is going to impact you. So let me go through exactly what we're looking at as far as what the law says. And it's really odd because I know there's been a lot of buzz about this. But the reality is what we're dealing with here is, I don't know whether you can see this or not, the part highlighted in yellow and going up on the next page. That's really the meat of the law here. So we're talking about a total of 3 sentences. And it seems like it's very small, but obviously there's a lot to unpack in those 3 sentences. And I hate to read at a screen, but I'm going to read to you the portion of the statute that's really important here. So the law indicates there is a rebuttable presumption that the contraction of coronavirus disease 2019 or COVID-19 by an essential employee, including but not limited to a healthcare worker or a public safety worker, is work-related. The presumption shall only apply to an essential employee who performs functions pertaining to those roles and involving interactions with the public during the public health emergency declared by Executive Order 103 of 2020, as extended by subsequent executive orders. And the next part of the statute is how to rebut the presumption. It says this prima facie presumption can be rebutted by a preponderance of the evidence showing that the worker was not exposed to the disease. So there are really 3 parts to this. Number 1, there's now a presumption of compensability for a worker that is within that category that develops COVID-19. Number 2, who are these healthcare and essential workers that are covered by the statute? And number 3, if they fall into that category, how do we rebut the statute? The first question I had when I saw the statute is, does this make any sense? And if you go back to the beginning of COVID when it hit, like I said, New Jersey was on the front lines. Things shut down fast here. Other parts of the country didn't shut down sometimes until months later. So we got hit in the very beginning without any guidance as far as how this was going to be handled. But from day one, the healthcare workers and medical providers, emergency personnel, they were still on the front lines. They were out there exposed to this as New Jersey numbers went crazy. That makes sense. Grocery workers, grocery stores were still open. Some emergent businesses were still open. At that point, we're talking March, beginning of April, a lot to protect these people made sense. Now we're looking at October. We're 7 months after these closures began. The state of emergency has been continued multiple times by the governor. But the list of employees that are covered, and Brittany's going to go over who's covered by this, has just continued to rise and rise and rise. And the real question is, now that businesses are primarily open, even if not at 100%, most people in some form or another are back to work now. Does this presumption still, or is this presumption still necessary? Does it make sense now? I would argue that it doesn't. Unfortunately, the law had been proposed a long time ago. Everybody wants to be seen as being proactive, doing something to help people. And unfortunately, because of that, now the presumption is in place and the list of people that's expanded. I did want to indicate one thing I forgot to mention early on. We do have a lot of people here today. Thank you for coming again. I do want to be able to answer some questions. So at the bottom of your screen, if you roll your mouse over, you should see a Q&A section. Because we have so many people, I would probably rather not do the raising hands and unmuting people. But if you do have questions as we go, feel free to type them into the Q&A and we'll get to them either as we see them or towards the end. We can go through some of those questions. So, all right, getting back to the statute, I personally think that there are some real questions with why this was passed now. I think that we are past the time when it really made sense. In the beginning, when grocery store workers were really exposed, they were a very specific risk. Emergency workers, obviously, that's sort of gone because now everybody's out there. When you're out on the roads, you can see there's a lot of cars out there. People are going back to their offices in limited numbers, and it doesn't really make much sense. Cliff Goldstein, our CEO, actually raises an issue about whether this is constitutional at all. You're changing legal burdens of proof, and there's a real question about whether that should be allowable under the law at all, to basically take away a burden of proof. That's the foundation of what our law is going to be. In addition to that, can you protect one group of employees without protecting another group of employees? So there are all kinds of constitutional questions here. There are questions of fairness here. Unfortunately, we're now stuck with this statute. So because we are stuck with it, well, number one, I want to make sure that we all understand what the impact of this is. And number two, I want to make sure everybody realizes that this is not anything to fear. This is not a situation in which we are going to be getting hundreds of thousands of these claims coming in. So let me go through the limitations first of all. The statute itself is very specific as far as what it applies to. It is very specific to this particular COVID-19 outbreak, and it only applies during the state of emergency declared by Executive Order 103 by Governor Murphy, and any extensions that he gives. Now, he has had probably 5 executive orders since then extending the emergency. One was just signed a couple of weeks ago. So the emergency is going on for a while, but once this state of emergency is lifted, all of this statute goes away, and it will apply retroactively to the period between March when it started and when the executive order is lifted, but future claims will not be involved. And that's sort of an odd situation because let's say, just for the sake of argument, let's say that the order is lifted November 1st. If you have a coworker who contracts COVID October 30th, they're going to be covered by the presumption. Now you have a coworker who contracts COVID November 15th, worked literally right next to that person, they're no longer entitled to the presumption. So there are definitely some oddities involved in this. And again, this is only going to be in existence during the declared emergency. So as soon as that emergency is lifted, the ability to bring these claims with the presumption is going to be over. My question was, do we really need this statute at all? New Jersey does have an occupational disease statute. It indicates that shall include all diseases arising out of and in the course of employment, which are due in a material degree to causes or conditions which are or were characteristic of or peculiar to a particular trade, occupation, etc. So we already have a statute that can cover things that are peculiar to a particular employment. And again, I'm going to continue to use the grocery workers as an example here. If you have grocery workers that are out and are exposed to the public when the rest of the public is shut down, obviously that's a risk that's peculiar to that employment. Does the statute really fit that situation? Maybe not, because for the most part, COVID isn't something that you're going to get over time. It's going to be a particular exposure. Did someone breathe on you? Were they touching something that you touched after that? Is it something that's in the air for a particular moment? So it's a question of whether that occupational statute really applied. The other statute that's really important here is the post 9/11 statute that came out. And after 9/11, because a lot of New Jersey emergency workers were involved in the cleanup, there were a lot of exposures there. And it was proven medically that there were a lot of pulmonary issues that came as a result of particular chemicals that were involved at the 9/11 site. So a statute there was passed that if you were exposed to that and you developed these conditions, there is now a presumption that it's work-related and you receive workers' compensation. That makes sense. But this statute goes a little bit farther even, because we don't know that there's exposure at these places of business. We can't prove that because you worked at a grocery store, that's where your COVID exposure was. But yet, even without that, they extended the statute even further and said, we're just going to assume this pandemic is so big, we're going to add everybody who's an essential worker. We're going to assume that they've been exposed now. So it really creates an additional presumption here. And it is definitely much wider than anything that we've had in the past. So the question is, could they have simply evolved that post 9/11 statute to something a little broader that would encompass more situations? They chose not to. They chose to go with this specific statute. So we now have a statute that applies just to this. It's a temporary statute that will go away once the state of emergency is lifted, but it is something that we have to deal with here. Britt, why don't you talk a little bit about which businesses are protected and thoughts about why particular classes are involved?
Sure, Mark. First off, good morning, everyone. We're so happy to have everybody here. We've got a great turnout. And again, if you have any questions, please feel free to type them in and we'll get to as many as we can. But so the statute specifically defines essential employee, and you can read this directly from the statute, an employee in support of gubernatorial or federally declared statewide emergency response, or an employee in the public or private sector with duties and responsibilities, the performance of which is essential to the public's health, safety, and welfare. So we're talking about covering essential employees. And so what does that really mean? When we think of essential employees, we automatically think of the employees on the front line. And Mark had mentioned the example of the grocery store worker. We have the doctors, the nurses, the police officers, the EMTs. But when you actually go through the statute and you go through the executive orders, which I'm actually going to do in a minute, the statute could really be interpreted to cover such a wide range of employers and their employees. Throughout the public health emergency, the term essential is defined several times, and it's vague. So the first time that the governor really defines essential is in Executive Order 104, excuse me. He provides a list of what he deems essential employers or businesses. And this list is airports, train stations, medical facilities, office environments, factories, assemblages for industrial or manufacturing work, construction sites, mass transit, and purchase of groceries or consumer goods. The order goes on to close schools down, but allows exceptions for limited cases. Those who provide essential non-educational services to students, such as lunches. So you could see some, teachers or administrative personnel within the education employment that may be grouped into this essential category too. The governor then goes on to declare Executive Order 107, which really modifies Executive Order 104, and he adds to this list. He expands this list, and he adds farmers markets, dispensaries for medical marijuana, retail functions at gas stations, convenience stores, hardware and home improvement stores, retail functions of banks, laundromats, dry cleaning, pet stores, liquor stores, auto mechanic shops, mail and delivery stores. And sorry for listing everything, but I do think it's important to sort of go through everything that was added to the list from 104. So now we're talking about a much wider group of employees that are designated as essential. Another vague interpretation of what is considered essential is construction workers. So like I just mentioned in the beginning, all construction was to maintain operations without interruption, and it was declared essential. And then in Executive Order 122, the governor starts specifying what is and is not essential construction. And the order provides a long list of the essential construction examples. And I won't go over it completely because it's very long. But some of the examples are projects necessary for the delivery of healthcare services, transportation projects such as roads, bridges, and mass transit, utility projects, projects involving schools, projects involving essential retail businesses, projects under contract, and the list goes on. And if you read through it, it's actually hard to pick out what may be considered non-essential construction. So it really still appears, again, to include all construction. And again, we're looking at a very wide group of employers that will fit into this category. So while it does appear that more employees may be covered under the statute than not, some groups do appear to have always been excluded from the statute. And it's really important to note that there's really a difference between what is considered essential and then versus what was permitted to stay open or reopen during the emergency. So per Executive Order 104, restaurants were able to stay open only for what the governor called necessary delivery or takeout services. But he doesn't specify this group as essential. So whether or not they're included still remains to be seen. Casinos, entertainment venues, such as movie theaters, gym and fitness centers, they appear to have always been excluded from essential businesses, even when they were permitted to reopen. Executive Order 110 closes down child care services, except those that care for children of essential workers. And then Executive Order 149 reopens all child care services, but never deems them essential. So it would appear that these teachers or caregivers may not be covered. Another example of what type of employees appear to be excluded are hair salons, nail salons, spas, tattoo shops. They're never deemed essential even when they were permitted to reopen back in June. So again, Mark mentioned this. Does it make sense that, does the statute make sense altogether? Specifically in this situation, can the liquor store clerk is protected, but the trainer at the gym is not protected? Or the daycare teachers for essential workers might be protected, but the daycare teachers for non-essential workers may not be. So I don't really know the answer to that. And I think the takeaway here is that what it means to be essential may take some analysis if and when you start to receive these claims.
I mean, to me, it raises a real big question. And it seems very, very strange to me that if I go to Home Depot to go pick up some things around the house, construction companies and home improvement companies are considered essential. So I'm in the checkout line at Home Depot. The person doing the checkout is covered by this statute. I take some friends I take my kids over to Topgolf, where there's probably going to be more interaction with your server. They're not covered. So to me, there's a lot of holes in this statute. It seems like it was very hastily put together, and it raises a lot of questions that aren't answered here. And that's sort of what we're going to have to go over as we unpack this, and as we start to appear in court on this. We have not seen a ton of new claims show up. I do think that there is going to be a little bit of an influx because attorneys were refusing these claims before. They were looking at them as minor claims are not worth taking. Now with the presumption, I would imagine we're going to start to see more. Although I still don't expect a massive rash of claims. You know, look at the demographics here. You have more than a third of the people are over 65 or under 18 that are probably not employees. So you're immediately getting them out of the way. Of the 200 and something thousand that were diagnosed, there's a large percentage that have either had no symptoms and never got any treatment other than just the diagnosis and quarantine yourself. And those aren't going to be claimed. What we're really talking about here is the small percentage of people that have unfortunately passed away. Of the 16,000 or so that have passed away in New Jersey, more than half of them are over 65 and weren't working. So we're somewhat limited as far as the number of people that we're going to be seeing. But we're really concerned with the patients that were hospitalized because those bills tend to be between $35,000 and $45,000 for a hospitalization inpatient for COVID. Those numbers are published online. And you know, the people who may have developed COVID and develop additional symptoms over time, whether it's pulmonary conditions or other internal conditions that may not directly be COVID, but may be related to COVID. And that's a real concern. One of the questions that we're going to have to worry about when we're in court is, okay, let's say now your worker developed COVID and they recovered from COVID over the course of 2 weeks to a month, all right? They were on some medications, they're better from COVID, but now they're left with a longer term pulmonary problem. And maybe they had some pre-existing asthma or some pre-existing pulmonary problem before, but now they've developed a clearly aggravated pulmonary condition. Have you now bought that condition? Are you going to get stuck with monitoring that condition theoretically for the rest of the petitioner's life? And as an aggravation to a related condition, are they entitled to the presumption under COVID? So it really does present some problems. And in those rare cases, I don't want anybody to panic and think this is going to be a widespread thing, but it does have the potential for some of these cases to really turn them into a much longer term nightmare. And that's what we really, really want to avoid. We did get a couple questions. I just want to address them real quickly. Number one, what happens if one of my employees who works for another state but gets injured while doing the job in New Jersey? In this case, let's assume we're talking about developing COVID. If you are injured in New Jersey, if you develop COVID in New Jersey, it's going to be a compensable New Jersey claim, even if your primary employment is out of state. So let's say you work for a Pennsylvania company, you're working on a particular project in New Jersey, and you develop COVID within that time frame of manifestation in New Jersey, and you filed a New Jersey claim, you are going to be probably entitled to that presumption there. New Jersey is one of the odd states. As long as you're injured here, you can file here, period. So you could live in another state and you can file in multiple jurisdictions as well. Now, if you do file in multiple jurisdictions, New Jersey will give you $1 credit for whatever you received in the other jurisdiction, but you can still file here and get the dollar value difference. So just to throw out fake numbers, let's say your claim is worth $50,000 in Pennsylvania and you receive an award there, and it's worth $60,000 here. You'd receive the award here with a credit for the $50,000, and you would get the additional $10,000 to fill in the gaps. That's how New Jersey works. The other question that we got is a construction worker on a new building involved in close proximity to the public? The question is, does the proximity to the public matter? And if they are injured, and again, they develop COVID during that time frame, they would get the initial presumption. And that's where the next part of this comes in here, is how do we rebut the presumption? So I'm going to use that scenario to sort of bring in how we do that. We know that a lot of times there are obvious questions, and let's take our grocery worker again. Now, our grocery worker tests positive for COVID, or actually, in this case, let's take the construction worker. The construction worker tests positive for COVID, and we know they worked within the last 2 to 14 days, because that seems to be the period which it takes to develop a positive test. So we know they were on site within 2 to 14 days, so they're within the risk time frame. Now they've developed COVID. They do get that initial presumption that they developed that at work. So it raises obvious questions. Do we know whether they were only at work? Do we know whether they were out in social situations? Were they involved in other gatherings? Do they have a family member who developed COVID? Was there social contact with friends? Were they out at restaurants? We're immediately going to start to question what other situations that worker would have been in that could have exposed them to COVID. So the real question that we have here is, the way the statute reads is, to rebut the presumption, we have to rebut the fact that they were exposed to COVID at work. The real question with that is it enough for us to show we know they were exposed somewhere else? Does that rebut the presumption? That's not technically showing that they weren't exposed at work. And I think what we're really going to end up with is a very judge-specific situation here. There are some judges that are going to look at this and say, well, wait a minute. We know they were exposed at home. Their parent has it. I'm going to assume that that rebuts the presumption, and we're going to find this non-compensable. Other judges are going to say, well, we know they were exposed at home, but we don't know that they weren't exposed at work. So we're still going to keep the presumption in place. That's the real problem here. So when you're looking at this, as far as ways to rebut the presumption, here's what we're going to be looking for. We're going to be looking for as much background information as possible. We want to know everything about this person's life. And as the employer, you guys are the first line of defense in that. We want to know, has anybody you've ever known tested positive? Have you had any contact with them? What public places have you been to? Were you at a restaurant? Were you out playing sports with your friends? Did you go to a bowling alley? Did you go to Topgolf? Did you go to a restaurant? We want to know everything about this. And New Jersey does allow special interrogatories in certain cases, and we're probably going to end up having to serve those to get as much information about where they've been as possible. So let's blur the lines as much as possible. Let's find other possible exposures first. Then we want to go to the place of employment, and this is really the key. How do we rebut exposure at the employment? we show that the employer has put the worker in the best possible situation. So let's take our construction worker. The question is, were they in close proximity to the public? Well, that's what we want to know. We want to know, is there any interaction with the public? Are they only in this construction site? Are there only construction workers there? Are there any other people walking through? Inspectors? Is there any place where the public is going to be exposed to them? If you can show in that construction site that the only people that this worker was exposed to were the 6 other construction workers on the job, none of them have COVID, then you've got a real excellent shot of showing that the exposure wasn't at the employment, and you've now rebutted the presumption. Let's go back to our grocery worker. When I go to my shop right, I'm dealing with a grocery worker who's behind plexiglass, wearing a mask, wearing rubber gloves or latex gloves. I'm on the other side of that plexiglass the whole time. I've got my mask on, required. There is no breathable interaction between us. So as long as we can prove that that's where they are the whole time and that there's no exposure here, we've got a real good chance of rebutting the presumption. Now you're going to need to show a little more than that. Where did they go on their breaks? Was there any point where they don't have a mask on in the store? Is there any point where there's a large gathering of public people where the COVID could be airborne? Is there any area where they have exposure with outside people, delivery people, anything like that, packers? So we want to get through the situation of where they work, what are they exposed to, what protections do we have in place? Are we using bleach or other antimicrobials to wipe down the station constantly? Are they given gloves? And you want to keep track of people that are in the store as much as possible. So one of the things also I do want to mention is New Jersey does have a statute that indicates that failure to make use of a required personal protective device is a defense to compensability. Now, it wasn't meant for this situation necessarily, but it would still apply. So in this case, if you're requiring your employees to wear masks and gloves, if they're not, document it. You want repeated written warnings that you've told them they need to. Without the repeated written warnings, you can't use the defense. So if you catch your worker going into work and they're not wearing their mask and you have to warn them, write it down. Make sure they sign off on it. If you have to warn them a second time, write it down. Now you've got repeated written warnings. If they're not making use of the mask at that point, we might be able to use the Section 7 defense of not using a personal protective device. So that gives us another option here. We want as much information as possible here. You might want to go around and inspect your employees and say, hey, we check the registers every hour to make sure they're wearing their masks, to make sure they're wearing their gloves. We make sure that it's wiped down every 15 minutes. Again, the more we can show a judge that we've done everything right in accordance with what the law is, taking every possible protection, we're limiting the amount of potential exposure to COVID here. And whether it's going to be enough is really going to be judge specific. But we want to show as much as possible for the employer. So again, the more we can show we've taken steps to prevent exposure, we've got our employees behind plexiglass, there's no interaction, our wait staff is told to stand 6 feet away, they put things on the table, they're not shaking hands with anybody, and then they walk away. Those are the kinds of things that we need the employers to look at. So document the workstations, document the protections that are being taken. Impact of the phrase close proximity to the public. The reality is we don't know. And I would imagine the real answer to that is, can you show that you are doing what the prevailing theories are? So right now, 6 to 12 feet. If you show your employees are always 6 to 12 feet away, they're always protected behind plexiglass, I would imagine most judges are going to accept that. And that's really what we're trying to do. We're trying to put up as good a face as possible. We're doing everything right to protect our employees. We know they've got other potential exposures here. We don't have to conclusively disprove exposure at the employment. We have to prove by a preponderance of the evidence that they were not likely exposed here. So again, this is where the muddying the waters comes in. If we can show, we know they were out at their kids' soccer game with other parents, they went out to a restaurant, they spent time with family, they spent time with friends, and here they are at work, but they're always behind plexiglass, they're always masked up, they're always wearing gloves, they're never touching anything, there's no interaction with people specifically. Me personally, I think that's a preponderance of the evidence. Will every judge think that way? Not necessarily. Do we need an expert to rebut the presumption? Short answer is probably. Long answer is it really depends on what phase of the litigation we're at. Again, most of these claims are going to be simply, I was diagnosed with COVID, I missed 2 weeks of work, maybe even had an inpatient hospitalization for a few days, then I was home and then I was fine. That's the bulk of these cases. So what we're looking at is medical bills that can usually be compromised down because of the compensability issues. A couple weeks lost time from work, and hopefully not much permanency from this, if anything. So we can immediately use the factual situation to talk about a Section 20 right away. And if we do that, we're not going to have to go the expert route. The only reason we wouldn't want to go the expert route is to save you time and money if it's a claim that we can close out quickly. But if it is a case that's going to go through litigation, yes, we're going to want an expert, probably an internist or an infectious disease expert, to say, based on these exposures here, this was not likely to contribute to COVID. They were not likely considered to be exposed within the terms of medicine. So that's a good way to go. And we've started to look at a couple of experts. In fact, I just talked to a company yesterday that does medical experts, and we started to get a couple of names for people that can do this. And they're going to start looking into it because I do think we want to line up our people. We don't really have a group right now that specializes in this, but we do want to make sure that we have a couple of doctors that have studied COVID, studied exposures, and can start to really rebut what is enough here. Grocery workers exchanging money and coins, and they touch their face. Again, I mean, yes, is that going to be enough? If my real question is going to be, how do we know that person who they exchange money with has COVID? So you're talking about a real gray area here. Let's say in a situation with that grocery worker, the grocery worker is wearing gloves, they exchange money with the customer, they then touch their face, and they develop COVID. Fine. The real question is, like I said, can we prove whether or not that person had COVID or not? Now, in a perfect world, if someone develops COVID, the CDC or Health and Human Services or the New Jersey Department of Health should be contact tracing. They should be contacting places where this person was. So theoretically, if that person was diagnosed and they get the background from them and they say, yes, I was in Giant Supermarket or I was in ShopRite within 2 to 14 days, they should be calling that store to let them know. In practicality, that doesn't happen. So yeah, we have to establish again, where else could they have been to contract COVID? And is this really enough? If they say I scratched my face for 2 seconds, again, this is something we're going to look to Section 20 because I don't know that there's a definitive answer to that. Again, we'll use the expert to say maybe that's not enough, and hopefully we can do a Section 20 at that point. The real problem, like I said, is when you have a situation like that, where it's a very limited situation, a very limited case, a very short period of exposure, it's easy to Section 20 that when all they've gotten is a positive test and nothing really after that. We're talking $1,000, $2,500. When they've now been in the hospital for 2 weeks and you've got a $40,000, $50,000 bill, and now you've got pulmonary problems on top of that, and they're having lingering symptoms, the anosmia, they can't taste anything, they lose their sense of smell, they have ongoing problems that we really can't resolve. Now you're talking about a much bigger situation. So a 2-second face scratch can turn into a really large Section 20. And that's something that we're going to really see how it plays out. Right now, I don't know that we have an answer to that. So we're going to have to see what our experts say. We're going to see what the conditions are that develop, and we'll have to go from there. I do want to talk for a second about what the benefits are. There's a real question about when these benefits start. And the statute says that if they lose time as a result of contracting COVID, you become responsible for that. So if they're out for just 2 weeks and they've contracted COVID, you would owe them temp for those 2 weeks. Now, assuming they clear it, they're cured, they come back to work 2 weeks later after 2 negative tests, your benefits end. And if there's no residual, great. You pay their 2 weeks of temp, you pay whatever testing that you need to pay, and you're done. Very inexpensive claim. What happens now when you have a worker who says, this customer came in, they were coughing and sneezing. I'm worried about this. And you say, go home, get tested, don't come back until you're tested. Now they take a test. It's not one of the 15 or 30-minute tests. So now they're home for 2 weeks quarantining because you don't know whether they've got COVID or not, and you don't want to let them back in the workplace. It could take 14 days for this to develop. So now they're home for 2 weeks. Do you have to pay them temp? The answer pretty clearly in the statute is no. The statute uses the words in no uncertain terms for contracting COVID. If they didn't get COVID, it's not temp, even if you have them out for that, for the testing and to watch the situation. So, be careful about that. I don't want to see people starting to pay temp under the theory of it could be COVID. But if they test positive, you would owe them temp. Now, that runs into a whole different situation with false positives. What happens if 3 days later they test negative again, and then you could stop the temp right away. Remember, temp doesn't start until the 8th day. I think that's really all that I have at this point. Britt, did you have any other issues?
Well, one thing that really popped out at me when I was going through the executive orders is that in 107, Governor Murphy declares that all state employees are to utilize work from home arrangements for both essential and non-essential employees when feasible. So it brings up the question, does the statute extend to essential employees who work from home? So for an example, say you are considered an essential employee and you're working from home, and maybe you have a babysitter at your house watching your kids, and your babysitter exposes you to the virus. Are you protected by the statute? And that's really going to be another thing that we're going to have to see play out.
Yeah, and that's really tough. I mean, how do we prove what has or has not happened at home? That's going to be really difficult. But again, I don't think we're going to see the explosion of cases that people are worried about. I do think that we're going to see some of these smaller ones. And I think it's more likely that we're going to see a rash from one or two attorneys where they collect a lot of these tiny little $1,000, $1,500, $2,500 Section 20 cases, rather than a lot of different attorneys taking these small cases. Because we did get one more question: can we obtain contact tracing records, or are they protected by privacy laws? That's part of why these attorneys are not going to likely take these cases. I'm going to ask for the moon, and I want to know everything about this person. So, if you want to collect money for a compensable claim, and it's my burden of proof to rebut your exposures, I want to know everything possible to try to rebut it. I'm sending out those special interrogatories. We may make a motion for deposition, and that's really rare in New Jersey. But this is a special situation with a special statute that switches the burden of proof against us. I think we've got a decent argument to sit somebody down for a deposition here, or at least take some trial testimony on day one, with the understanding that we'll stop the trial and go into investigation mode afterwards. I want to know everywhere you've been within that 14-day period. Not just do you have anybody at home. I want to know every single place you've been. If you left your home, I want to know about it. And then the next question, can we get the medical records? Can we get family medical records? Probably not, but we can certainly ask about it. We can certainly ask whether they know anybody in the family that's been exposed. If they went to the restaurant, they went down the street to the diner, I want to talk to the diner. I want to speak to somebody there about whether anyone there has had COVID, whether any customers have called about COVID, whether they've been contacted by the Department of Health. So we're going to muddy the waters as much as possible, and we're going to get as much information as we possibly can. And because of that, it's going to be an awful lot of work if you want $2,500. So we're hoping that we really don't see a rash of cases come in here, but there are certainly going to be a few. I also think something to keep an eye on, I don't think they're necessarily going to come in right now. Right now, there are still people worried about working and about making sure they have an income. When the emergency is lifted and businesses are back to normal, I think that's when we might see more cases. And remember, they've got the 2-year statute of limitations. So let's assume, for the sake of argument, that a vaccine comes out around the middle of next year, the state of emergency is lifted around the middle of next year. We're going to be well within that 2-year time frame for people to come back and say, hey, I had COVID back then, I'm entitled to something. Of course, we'll also have a much better idea of what the residuals are at that point. Next question we got is, should these claims be resisted in general until such time as one is proven to be an essential worker? Absolutely. I think they should be resisted pretty much every time. The only time I wouldn't really resist a claim, if you have, my cousin was a nurse in Manhattan, worked at Mount Sinai Hospital right in downtown Manhattan. He developed COVID. He was working on a COVID floor. He was exposed every day. He knew he was exposed every day. In that situation, you're going to accept that claim. I mean, to deny that is just going to end up resulting in motions and fees and all of that. Other than that, I would generally take a position of denial, because again, you're probably only dealing with a couple weeks of temp and maybe some medical bills. So there's no downside to denying that claim. And then we can do a section 20 and factor in what we would owe. So yeah, I would take an initial position of denial for just about anything. What do you think, Britt?
Absolutely. I mean, just even going through what it means to be an essential worker and how gray it is, absolutely. Put the proof on them to prove that they are an essential worker.
Yeah, I mean, I think that's really all at this point. If you have any specific questions, my information and Brittany's information are on the firm website. Phone numbers, my cell phone number is on there. Do not hesitate to call. We're happy to answer any specific questions you have about your business in particular, about cases you have as adjusters. Yeah, don't hesitate to give us a call. We're more than happy to help out any way that we can. And if you think of anything over the next few days that you didn't think of right now, just let us know. We're more than happy to go through anything here. But again, thank you guys all for coming. And let me just check, make sure there are no other questions here. I think we're good to go. Sorry if I missed any. Like I said, just email us or call us.
Oh, there was one more, Mark. Will
Okay.
will we be able to access contact tracing? Oh, contact tracing.
I think it's going to be really hard. We would have to reach out to the Department of Health from the state to see what they've got. There is actually an app now that New Jersey just came up with a couple days ago where you can see what's going on around that area. But as far as being able to trace people individually, I would think we've got HIPAA issues with that. And that's something that's going to really have to play itself out. Can we get an order from the court to allow that information? Again, I would think the more serious the case is, the more likely we are to be able to get that. If you've got somebody who had 2 weeks out of work and they're back to work and they're fine, and we're talking about anywhere from a $2,500 to a $5,000 case, the court's probably not going to open up contact tracing. But if we have a situation where someone has been out of work for a long period of time, they've been hospitalized, is it possible we'll be able to get an order to get other people's medical records? Maybe. We would have to really do a lot of research on the interaction with HIPAA and their privacy. But we can certainly contact the state and get the information from them if we've got a court order. But that's probably about as far as we can go. And then if the state doesn't cooperate, I'm not sure what our options really are. But we'd have to fight all that out. That becomes a much longer process. We might need to go to civil court with subpoenas to try to get orders from civil judges. But yeah, if we want records from other people, it's going to be rough. But as far as the contact tracing, I don't know exactly what the Department of Health has. We're going to try to get in touch with them and try to get a sense of what's available from them and whether they're allowed to reach any names or release any names rather. That's a good question. So I'll take a look into that and I'll see what we can find out.
We did get another question. Did the statute define who is an essential worker? As a retailer, we kept our employee in the supply chain working, and as a company, we deemed them essential. Can that be argued by the employee? I think that what you define as essential and what the state has defined as essential are two different things. So whether or not your business is considered essential per the statute, I think is really going to trump on whether or not you have called your employee an essential. What do you think about that, Mark?
Yeah, I mean, I would think anybody who works for any of the named stores or any of the named businesses would be considered essential. But that's an interesting question, because what if, does everybody who works within that store constitute essential? I mean, Obviously within the grocery store, the cashiers certainly are, but are the clerks in the back room who never come out in contact with the public? Um, you have other sort of side workers within the grocery store. Are they going to be considered essential? I mean, honestly, we would probably argue at that point that the spirit of the law doesn't protect certain people. And it's meant to really protect the people that are on the front lines, that are out there. But yeah, if you've got somebody that isn't really in that situation, well, number one, we're going to be able to hopefully disprove the presumption, and because they weren't exposed if they're in the back room. Number two, yeah, should they really be considered essential? I would argue no. Remember, we can make all the arguments we want. There's nothing preventing us from making arguments. One more we got with the thought process for the 2-year statute. Should employers ask questions when employees return to work if they contracted or had COVID? If yes, where should it be stored? Absolutely, in the personnel file, you should find out everything you can. Were you diagnosed with COVID? What doctors did you go to? Were you in the hospital? Did you stay at home? Were you exposed to anybody else after that? Could you have infected other people? Yeah, get as much information as possible. And if they refuse to answer, I don't know that you can make them answer, but that certainly doesn't look well on them. I think that's all we've got for now. So like I said, if you guys have any questions, email us, call us, happy to help out. And thank you all for coming. Really appreciate the time.